Greetings! Welcome back to the Politics of Prosecution video series. This is episode 5, where we look at the interaction of prosecutors and politics. Our first episode was an introduction. Our second looked at the political process. Our third looked at the criminal justice process. Our fourth introduced the idea of prosecutors. And now we have reached a stage where we can start looking at the interaction between prosecutors and politics. Our next episode is going to switch it around and look at politics and prosecutors. Why do we say that? Why do we need to look at this interaction between prosecutors and politics? Because there is a concern among many in the public that prosecutors become politicized. In other words, they do things for partisan interests, they do things for personal interests. They do things for the personal or political benefit rather than in the interests of justice. Remember from episode 4, we have this idea of prosecutors as ministers of justice, and if they are doing things for political gain or for personal gain, they cannot be doing things for justice. Prosecutors are affected by politics, or prosecutors can use politics in 4 different ways. The first is through policy. So prosecutors cannot prosecute every conceivable case, and they must therefore decide which cases to prosecute and which cases not to prosecute. Often this takes the form of policies, whether they are formal written policies or informal, unspoken, or implied policies. Prosecutors have to choose what to prosecute and what not to prosecute. Second, prosecutors have to be selected somehow. When they are selected, it becomes a political process. And so we have to look at the different manners, the different mechanisms used to select prosecutors, and how they have to appeal to a certain political base in order to become the prosecutor for a particular jurisdiction. Third, we look at how prosecutors can use their position for political or personal gain. They can use it as a weapon. They can use it to attack political opponents. They can use it to benefit themselves in some way, shape, or form. Finally, the last way that prosecutors can be influenced by politics is they can use their position to shield their friends, to shield their political allies, to shield themselves from criminal investigation or criminal prosecution. And so in this particular episode, we're going to look at all 4 of those ways. We hear about politicized prosecutors quite frequently. The current presidential administration has been accused repeatedly of politicizing the Justice Department. President Trump, early in his administration, said he had the absolute right to do whatever he wanted to do with the Justice Department. There were concerns expressed about who the president was hiring in that position. When Attorney General Jeff Sessions did not stop the Mueller investigation, the president became irritated with him to the point where he removed Attorney General Sessions from office and replaced him with Attorney General William Barr. And since Barr has been in office, Barr has taken steps both in terms of hiring, both in terms of the Mueller investigation, to inject what people have said are the president's political interests into the criminal court process. But this is not something new with President Trump. We can track back through the last 4 presidencies and find allegations of politicizing the United States Department of Justice. In the Obama administration, under Attorney General Loretta Lynch, there were concerns that her relationship with former President Clinton and former Secretary of State Hillary Clinton had led to improper influence in the investigation into Hillary Clinton's emails. there were allegations the Justice Department changed its guidelines for determining when to prosecute high-level business executives in order to make it easier to prosecute those offenders, to impose or to implement President Obama's particular political ideology. We can go back to the Bush administration. The Bush administration fired a collection of United States attorneys within days of each other, all because those particular U.S. attorneys were not what they considered to be loyal Bushies. They were not people who were implementing the president's policies the way the president thought they should be implemented. We can go back further to President Clinton. On President Clinton's last day in office, he pardoned many people outside of the ordinary Justice Department policy. Many of those people were campaign donors, people who were well-known Democratic politicians and figures, and he simply let them out of jail on his very last day in office. Prior to that, there was much debate about when special counsel or independent counsel should be brought in to review conduct within the administration. There were efforts made to not prosecute people within the administration who were allegedly committing criminal activity. And so this idea of politicized prosecutions, politicized justice departments, has a very long history in our justice system. And so we need to break that down a bit and figure out what do we mean when we talk about politicized prosecutions. When is it permissible? When is it not permissible? Because, again, if you think all the way back to our introductory episode, we said that prosecution is an inherently political act, and so they cannot be totally separated. We can only sort of create a dividing line about when it's permissible and when it is not. So I referenced the 4 methods of politics and prosecution interacting. The first is this idea of policy. When we have elections and we choose somebody for elected office, they are presumably running based on certain policies. They are going to do certain things. Some of the ways that occurs is through criminal prosecution, through criminal law enforcement. So, for example, President Trump takes office. He says immigration is going to be an important policy. He is going to prevent people from entering the country. One way to do that is to increase the number of criminal prosecutions of those who are entering the country illegally. That reversed the Obama administration policy where they were not going to enforce this so strictly, that they were going to take steps to make it easier for people to get into the country. And so we have these political positions that different candidates are taking. It's only natural that they are going to take steps to implement them. In addition, we cannot prosecute every single criminal violation. If there are tens of thousands of federal criminal laws, there are thousands of state criminal laws. Every state has its own set of laws. They range from things as serious as murder to as minor as speeding tickets. If we were to prosecute every single violation of every single criminal law, there's not a single person in the country who would be safe from criminal prosecution. There is a title of a book by Harvey Silverglate that talks about the idea of 3 felonies a day. It's arguing that the average American person commits 3 federal felonies every single day, and the only thing that separates that person from criminal prosecution is the fact that prosecutors decide not to focus their efforts on that person on that day. And so we have to understand how these different preferences and how these different policies are coming about. In addition, prosecutors only have so much resources. Individual prosecutors can only handle so many cases. Sometimes if you're only handling drug cases at a state level, you may have as many as 200 cases at a time. Where if you're in the federal government and you're handling fraud cases, you may only be able to handle 4 or 5 cases at a time, simply because of the volume of material and evidence that goes with each of those cases and the work that is required to properly prosecute those cases. And so offices have to decide, how are they going to allocate those resources? Are they going to emphasize drug cases, or are they going to emphasize fraud cases? They need to make those decisions. So how do they make these choices? Well, one way that they can do that is through the seriousness of the offense. So they may say, we are only going to prosecute the most serious offenses. We could give you a list of 10 charges, and you could rank them from most serious to least serious, and most of you would probably have all of those charges in the same order. You would probably put murder first. You would probably put digging ginseng out of season near the bottom. And so when it comes down to having to choose, do I prosecute this murder case or do I prosecute this person for digging ginseng out of season, you're most likely going to pick the murder case because it's much more serious. But you may have ideological preferences as well. People may believe that certain cases are more important even if they're not as considered as serious. You may have a prosecutor who is particularly concerned with protecting the environment, and so they may place environmental prosecutions at a greater priority than other things. Or you may have someone who says, I do not believe the drug laws are appropriate. I do not believe that marijuana should be illegal. Therefore, I am not going to prosecute marijuana cases. It is in these situations where we have to really begin looking at that interaction and say, what happens if we carry this idea of discretionary policy prosecutorial decision making beyond where we think it should go? How far does the policy making authority stretch? Can someone refuse to prosecute a whole category of cases? Can someone write things into the statute so that only serious enough violations violate? Can somebody simply say, we are going to establish these criteria and then we will prosecute the case? So here are some examples. Again, using that marijuana. Can somebody say we are not going to prosecute any marijuana case no matter what happens because we believe marijuana should be legal? Of course, what happens to the person who has 5 pounds of it? Are we going to make an exception for them, or do we have a separate policy that deals with that? There are prosecutors who say we are not going to prosecute a stealing case unless the value of the amount stolen is $1,000. There's nothing in the statute that says that. In fact, the statute says it may be a felony as long as there's more than $500 stolen. State prosecutor may take office and say, look, I'm only going to prosecute if it's over $1,000. Are they allowed to do that? Is that permissible? What about the prosecutor who says, I am only going to prosecute a sexual assault case if I have an independent witness to corroborate what happened? Because otherwise it is just two people on opposing sides and becomes a swearing contest. We need that independent corroboration. Is that a justifiable policy? Right? And so this is where we begin getting into the difficulty of making these decisions, and this is where the politics of office policy making come into play. That's also why the second area of prosecution and politics comes into play, and that is the selection of who is going to make these decisions. Who is going to make the decision whether or not we're going to prosecute marijuana cases? Who's going to make the decision whether or not the value for stealing has to be over $1,000? It is the person who is in charge of that office. So how do we get that person? How do we get that person who is in charge of the office? Historically, when we look at these, the prosecutor was an appointed figure. The prosecutor was generally appointed by either the local court or by the governor of the colony or the state when the United States was first founded and the United States first achieved independence. Over time, that appointment switched to where it was pretty much the governor's call on who the prosecutors would be. That lasted up until the 1830s, when elections began taking over. There was a wave of democratic revolution in the United States. People wanted more and more offices within the government to be elected, especially at the local level. And so prosecutors rode that wave, and they became elected officials as well. And from that point, prosecutors then had to begin appealing to the public. Prosecutors had to begin affiliating with particular political parties, and as a result, politics enters into the picture. Now, just about every single prosecutor in the country is an elected official. They are elected at the local level. So, you will have somebody in Guilford County, North Carolina, who is elected. You will have somebody for Manhattan who is elected the New York City District Attorney. You will have somebody in Chicago who is the Cook County District Attorney. They're not answerable to the state. They're not answerable to the governor. They're not answerable to the Attorney General. They are only answerable to their local electorate, and that is who will select them. In some places, however, generally this is in Connecticut, New Jersey, Delaware, Alaska, the local prosecutors are appointed. The governor will appoint those people. That's the way it has historically been done, traditionally done. There are generally states with somewhat smaller populations, somewhat smaller geographic area, and so there is the single attorney general who might be elected, but then the attorney general will then make the appointments of who will be the chief prosecutor for each of those particular jurisdictions. So, for example, in the state of Delaware, there is a attorney general who is elected, and that attorney general will select a head for each office in each county. There are 3 counties in Delaware, and so that person will be in charge of that office. That person is not directly accountable to the people of that particular county in the same way as if that person was elected by those people in that county. Now, that covers the state prosecutors. We also have federal prosecutors. From the very beginning of their creation in the Judiciary Act in 1789, prosecutors have been appointed by the President of the United States by and through the consent of the Senate. Basically, the Judiciary Act of 1789 established that the United States District Attorneys, as they were called then, should be meet people learned in the law. Those were the 2 big criteria. A meet person is someone of high character. Someone who is learned in the law is someone who had a legal training, who had been admitted to the bar to practice law. Over time, the meet person standard has been replaced or removed, and simply the president is able to select whomever the president wishes to fill that office. Now, in practice, the president is not necessarily making that choice. Because the Senate has the advise and consent function, because the senators know the people in their respective states, the senators generally are the ones making the decision. The senators generally have a veto power over the U.S. attorneys in their particular state. They can simply let the Judiciary Committee know and say, no, this person isn't acceptable, and the Judiciary Committee generally will not go forward on that nomination. In addition, each of those senators, they don't know all the different candidates that they could choose from for a United States attorney. Therefore, often they will select committees of people within their state to interview and identify people who should receive that nomination. And so that's generally how the process is going to work. Once in office, they are really serve at the president's pleasure. The president has the absolute right to remove United States attorneys whenever the president believes it is necessary. The same thing applies to the Attorney General. Now, what generally is going to happen with these people that the president selects is the president is going to select somebody who is going to at least appear as someone who will support the president's agenda. So again, to go back to President Trump's agenda of limiting immigration and vigorously enforcing immigration laws, he is going to want to select people who to fill those roles who are going to actually prosecute those cases. For example, you do not want, or the president does not want, a United States attorney in the District of Arizona who is not going to prosecute people for crossing the border illegally. That would essentially undermine or undercut the president's policy. And so that is automatically going to narrow the list of people who the president may choose from when looking for a United States attorney. Now, of course, this doesn't always happen, and there are limits to this, especially when we get down to the level of individual cases, where there is an ethic where the president should not be involved in individual cases, and removing somebody from their office because of how they handled a particular individual case is generally seen as inappropriate. But what happens if the president doesn't choose somebody? What happens if somebody resigns the U.S. attorney position, the president doesn't feel like going through the process, or the president decides they don't want to nominate somebody new for that office? There are mechanisms in place to deal with that, one of which is that the district court judges of that particular judicial district will make the decision, and they will appoint somebody, and that person has the same exact powers, same exact functions as a presidentially appointed United States attorney. And in fact, that person probably cannot be removed unless the president decides to appoint somebody new in that position. The question now becomes, how effective are these selection methods, and in particular elections? Do prosecutorial elections even matter? Think about it this way. Can you identify your local state prosecutor? My guess is you probably cannot. Generally, people don't pay attention to big national elections. Many people can't name their United States senators. So how are they going to know who their local prosecutor is? In addition, generally on a state level, up until recently, there's been very little distinction between prosecutorial candidates. If you think about it, the range of options are not terribly great. How many people are going to run for office and say, I am not going to prosecute murder cases. I believe people should kill whomever they want to or rob whoever they want to. And so we're simply not going to prosecute those cases, or we're going to make it much harder to prosecute those cases. That's not going to get the person elected. What gets the person elected is saying that they are going to enforce the law fairly and justly, and that they are going to use office resources wisely and so forth. And so you don't see a lot of distinction between prosecutorial candidates. And so from an electorate side of things, they look and they say, what difference does it make if I elect this person or that person? They're going to do essentially the same thing. On top of that, people generally don't know what prosecutors do. How many people know what happens in their courthouse on a daily basis? Right? Most people don't want to show up for jury duty, let alone go down and watch court and see what the prosecutors are doing in the name of the people. And so prosecutors generally can operate without any real accountability. As long as their conviction rate is relatively high, as long as the crime rate is not exorbitant, no one is going to be removing them from office anytime soon. They're going to see, oh, this is the incumbent, let's keep them in office. That means, at the end of the day, prosecutors do not have a whole lot of accountability for the large majority of their cases. No one knows what they're prosecuting, nobody knows what the outcomes are. There is, however, a very small segment of cases where prosecutors are publicly accountable, and these, of course, are high-profile cases. These are cases that are in the news. These are the cases upon which prosecutors are judged on. If there is a high-profile case and they lose that case, that is what's going to remain with the voters. Conversely, if they win that case, that will stick with the voters as well. And so high-profile cases are treated differently than most cases simply because there is not the public spotlight on that particular case. What makes a case high-profile is simply, again, that relevance to the next election. Now, all of this has changed in the last couple of years. We have seen this rise of progressive prosecutors who are, in fact, presenting an alternative to the people from traditional prosecution. They are not running on the idea that they are going to prosecute to the fullest extent of the law. They are not running on a position where they're going to prosecute murderers and robbers and rapists. They are running almost on a position of saying we are not going to enforce the law as vigorously as the predecessor has. We are going to try to make the criminal justice system more humane. We're going to try to end these ideas of mass incarceration. We're not going to prosecute as many cases. They are saying we're not going to prosecute marijuana cases. They are arguing on we're not going to ask for cash bail in certain cases. They are saying that we are going to review wrongful convictions and make wrongful convictions a priority. We're actually going to let people out of jail. We're going to let people out of prison. This is a very significant break from traditional prosecutorial campaigns, and as a result, that is making these elections different from elections that have occurred in the past. And the people who are taking these positions are taking office. They are winning their elections, and as a result, we're starting to see this change in prosecution. But at the same time, the people who are winning these offices are doing so and must respond to the public. They're only going to win as long as they're doing what the public wants them to do. They tend to be Democrats rather than Republicans, and so they have a particular ideological agenda that they are going to implement, and they are doing that because they have an electoral mandate. They're able to do that because they have an electoral mandate. And for the most part, we don't have a problem with politics entering into policy decision-making, politics entering into the selection of prosecutors. Where we start having a problem, where we start crossing a line, is when politics begins to influence decision-making on individual cases. This is where we can use prosecution as a political weapon, or we can use prosecution as a political shield. This line between when politics is appropriate and when politics is not appropriate can be rather fuzzy. Right? We don't really know when you cross that line. To some extent, we say, well, we know it when we see it, but even different people are going to look at the same case and have different beliefs about whether politics was proper in this particular case or not. Let me give you a couple examples of what this looks like. Suppose I am the elected prosecutor for a particular jurisdiction, and an organization called Save the Animals gives me $20,000 in campaign contributions. And as a result, I announce that I am going to make the protection of animals and the prevention of animal abuse one of my office's top priorities. And so when I have to make a choice, if this is an animal abuse case, I am going to prosecute that case fully. I'm going to make sure it's investigated. I'm going to make sure that the owners of that particular animal and the animal receive justice. Right? Is that proper? Am I okay in doing that, or am I allowing the political influence that comes with a $20,000 campaign contribution to improperly affect my office policy? Suppose I make protecting our nation's elections my number one priority. I'm going to make sure that our elections are fair and honest. I'm going to make sure that our candidates and our office holders are held to the highest ethical standards. And I'm going to do that through criminal prosecution. Our office is going to vigorously investigate allegations of voter fraud. We're going to prosecute the offenders to the fullest extent of the law. I'm going to prosecute office holders if they are abusing the trust of their office in some way. And now it comes to election time, and someone from the opposing political party is committing, allegedly, some criminal activity. If I prosecute the opposing party, am I doing that for political gain, for political advantage? Suppose that it is my opponent in the upcoming election for district attorney. Is that improper? Am I improperly allowing politics to influence that decision? How about that I know or I use a specific case or a specific policy, and I use that for partisan political advantage, right? Or I use that to prosecute those who may donate to my opponent's campaign. So let's look at the Obama administration for a minute. If they were changing their policy to make it easier to prosecute corporate leaders, suppose that we prosecute corporate leaders of corporations that donate to Republican parties. Right? We begin damaging the reputation of those Republican preferenced businesses. Is that an improper use of politics, or am I simply enforcing the policy or implementing my ideological agenda? Right? Where do we draw the line in those circumstances? Let's change this up a little bit and look at it from the other side. Remember my $20,000 contribution from Save the Animals. Suppose that the organization is radically opposed to using animals as medical test subjects. Suppose that the Save the Animals group goes to the local university and breaks into the animal testing labs and destroys the labs, causing millions of dollars worth of damage. The case comes to my office, and because Save the Animals has contributed so much money to my campaign, I simply say, I don't think the case is good enough, or I'm not going to prosecute that case. Is that improper? Have I improperly allowed politics to influence my decision? Have I essentially used my office as prosecutor to shield a political ally? Suppose I believe that was the right thing to do. Suppose I believe that that's not a problematic activity. Is that the proper basis for refusing to prosecute that particular case? Of course, that hypothetical shows a very direct connection. What if it's more indirect? Suppose it's the friend of my campaign treasurer. So every campaign has to have a treasurer who's going to keep track of the money, file reports, and so forth. What if it's a friend of that person who has been accused or suspected of committing some sort of fraudulent scheme? And the friend goes to my campaign treasurer, who then comes to me and says, you know what, can you give this person a break? Or, you know what, this person made a mistake here. That's really not who that person is. They're acting out of character. Can we work something out where they pay the money back, or can we work something outside of the system? And in order to do my treasurer a favor, I say yes. Is that improper? Is that inappropriate? Am I using the power of the office to shield somebody from criminal investigation who may or may not be an ally of me? As you can see, these cases become very complicated. And we can keep building on them to make each one a little bit more challenging and a little bit more complex. And these are decisions that prosecutors have to face on a day-to-day basis. And so we have to understand how they make those decisions, and that is where the prosecutor's character comes into play. Remember, in episode 4, we talked about the different aspects of a decision to prosecute a case. And we said those individual factors are important. This is where that idea of character, of beliefs, of morality come into play, is making these difficult decisions. Now, there is one remedy for some of this, and that is the elected prosecutor can look at a case and say, this is a conflict for me, right? I may, when I evaluate this case, look at it because of my personal connection to it. As a result, that prosecutor has the ability to ask for a special prosecutor to be appointed, somebody who is outside of that process, who can take a more objective look. Now, of course, there's a problem with that. That special prosecutor is not accountable to anyone. This was the big complaint in the late 1990s with the independent counsel investigation into President Clinton, where they said the independent prosecutor was too independent. They could do whatever they wanted with unlimited resources and look under every single rock for any potential type of crime. And so that's the flip side of this politics and prosecution, is the politics provides some form of accountability. Nonetheless, that special prosecutor, if there is some basis for holding the person accountable, that will rectify or remedy the problem of having the potential conflict of interest for individual prosecutors. These situations can basically show up at 3 different stages in the case. They're most often going to show up at the charging stage. Prosecutors, as we've said, have the most discretion at the charging stage. It is literally unreviewable, but it can also show up in sentencing. We may give the person a lesser sentence. We've seen that most recently in the Michael Flynn sentencing. You can also do something post-sentencing. We saw that in the Roger Stone case, where prosecutors recommended a lesser sentence than what they had originally due to the request of Attorney General Barr and his belief about the particular case. And so all of these things begin factoring in. So that's sort of our look at the prosecutors and their involvement in politics and how politics can influence that prosecutorial decision. Remember, we said there's those 4 ways in which it is affected. It's through policy, selection, through using it as a means to achieve or obtain partisan benefit, and is also used as a way to shield or protect those close to the prosecutor. In our next episode, we're going to flip it around and see how do politics influence prosecutors. That will be our final episode, episode number 6. Until then, we hope that you will subscribe to this channel. We hope that you will follow us on Instagram at poly_n_pros or on Twitter at poly_pros. You can also find us, our podcast, on iTunes or Spotify. Until then, we hope to see you back.